The next case to come before the court is Chesley Bleck versus Midland Machinery Company, Inc. Each party will have up to 15 minutes to present your arguments. Or I should ask you, is everybody who you're expecting to be here?
Yes.
Yes, sir. Okay. Then I'll go back to giving these instructions. Each party will have up to 15 minutes to present their arguments. Of course, the appellant can reserve up to 5 minutes for rebuttal. And if you do plan to reserve rebuttal time, please let me know as I'll be keeping track of the time. The arguments are being recorded, so please stay behind the podium, keep your voices up, and remain there. You should not use the names of children or minors or victims during your arguments. Should that be in your argument, you can refer to them by initials or generic terms like the child. The judges have read your briefs, and we are ready to proceed when you are. So I'd ask the appellant, would you like to reserve time for rebuttal?
Yes, Your Honor, 3 minutes.
Okay, very well, then you may proceed when you are ready.
Thank you, Your Honors. I know it's been a long morning, afternoon, but hopefully this is the last one for today. My name is Paul Flowers. I represent the plaintiff appellant in this case, Chesley Bleck. I'm joined by Kevin McDermott and Anthony Gallucci. We're the trial counsel below, and Ms. Bleck is here in the black shirt. I'm not going to introduce her family members, but they're all here as well. Let me just briefly give the court the background of this. Max Stone was a Union 860 highway construction worker. On May 29th, 2000, he lost his life while working on a paving crew alongside of a large 6-ton road widening machine. I might just call it RWM to make it easier. What had happened was that a cable had detached from overhead on the roadway, crashed down onto the machine. It struck the operator who was seated in his chair. It swiped across the console and swiped the unprotected joystick. The joystick was the device that was used to move the machine backwards and forwards. Mr. Stone was where he was supposed to be, which was to the left of the machine. The machine is thrown into reverse. He's very tight to the machine. According to the coroner's report, which our experts go through, he was pulled under the machine and crushed. The whole case, the whole mechanism of death, is the inadvertent actuation of the joystick. That joystick did not comply with industry standards, and that's undisputed, although it's certainly not admitted. It's undisputed. The American National Standards Institute rules for hot mix asphalt construction machines 4.1.2.3 states, and I quote, "Machine controls shall be designed and installed such that they can be routinely operated reliably, safely, and easily from the operator's stand. The controls shall be protected to prevent inadvertent actuation." The defendant, the designer of the machine, Midland, did not do this on this model alone, the SPD-6. There were 2 larger road widening machines they had manufactured and produced, the SP-8 and the SP-10, where they included a center lock on that joystick. And in order for the operator to move the joystick backward or forward, you have to lift the center lock from its position, and only then could it be moved. It's a common design. Our experts have provided a depiction of it. Like I said, it's on the Midland machine and virtually every other machine of this type. It's the same thing you'll find on power tools, same thing you'll find on lawnmowers, on your stick shift in a car. You got to press a button before you can move it. That wasn't here. Despite this, Judge Cook granted summary judgment below upon the design defect claim. We're then here on appeal, and I'm sure the court is aware the standard of review is de novo.
Counsel, before we proceed, you mentioned when you first started, and I'm not sure how essential this fact is or material, but I know both sides talked about in their briefs, but you seem to say that he was standing to the left of the road widening machine, and then I think in your rebuttal you said he was standing behind it.
Oh, no. Yeah, no. If we say he was standing behind it, that's mistaken. He was definitely standing to the left.
Okay, because I thought one of the arguments was that these facts are just horrendous, so I just have to talk about them.
Oh, sure.
One of the arguments was that, that he was partially at fault, and because he was not in the right position and he was falling behind, and there would have been no way for him to have been sucked into the machine without him being right behind it.
Right, so, yes, there is the argument that he's partially at fault, they may even think he's fully at fault. You always get that in wrongful death cases, because the decedent is not here to defend himself. And they have the guys who are around him saying like, yeah, he didn't signal that the line was coming up, blah, blah, blah. And that assumes they were paying attention themselves. But he was definitely to the left of the machine, that's by all accounts. So he's what's called the dump man, and so he's over here, and he is following the truck, looking ahead, making sure that the asphalt's coming out of the dump truck in front of it at the proper pace, signaling to the dump truck driver to raise or lower the dump truck bed in which the road winder is pushing. He's doing all that. And as for what happened, the trial judge, for whatever reason, relies on all these guys who are around the machine saying, oh, this could happen, he could have jumped under it, blah, blah, blah. The coroner makes it very clear. I mean, the coroner says the mechanism of death when he was pulled under the machine. And the coroner knows this because the photographs of the autopsy show a large rectangular bruise on his thigh. And that bruise corresponds exactly with this large chunk of metal coming out of the left side of the machine. So Judge Carr, you're right. There's the argument he was hit because it was behind it. He wasn't behind the road winder. He was behind the apparatus that sticks out to the side, right by the tire. So as the coroner found, when he's hit and pulled under, it all happens very quickly. Even better photograph on this side, which was marked as a plaintiff's exhibit 8A. What's easy for me in this case is we have one claim, which is a product design defect, and it's established in the Ohio Products Liability Act, the OPLA. It sets out exactly what we have to prove. It's very simple. Under 2307.75, a product is defective if at the time it left the manufacturer, the foreseeable risk exceeded the benefits of the design. Here, the foreseeable risk that they were required to guard against on ANSI standards was inadvertent actuation of the machine. And not only do our experts say it, their engineers, Midland's own engineers, admit this. They admit this. So William McKendrick, he's the former design engineer in Midland, who's never mentioned in the defendant's brief, even though we quote him extensively. He knows the hazard exists striking a worker. On page 43 of his deposition, question, so a potential hazard does exist that the machine could go in reverse and possibly run over a worker, correct? Without the operator knowing it? Answer, yes. And then he talks about the backup alarm that exists, but unfortunately this happened too fast for the backup alarm to make any difference. And he knows that the risk is serious injury or death. Page 44, question, and the risk of coming into contact with a road widener inadvertently going in reverse and running over a worker, that risk could be serious injury or death, correct? Answer, yes. He doesn't even equivocate on that. And this is completely preventable. As they've done with their other machines, he testifies on page 40. Question, so the center lock helps prevent inadvertent movement of the travel controller. Answer, I would say yes. Question, or also unintentional movement of the travel controller. Answer, I would say yes. Or answer is just yes. It is not just former design engineer McKendrick. The current design engineer at Midland, the only one, Lili Kumar, who's not a licensed engineer, but he's still the design engineer there. He's trying very hard in his deposition to get his employer and himself off the hook since he designed this. But still, he acknowledges what he has to acknowledge. He recognized that there was the risk of inadvertent contact. So on page 38 is deposition. Question, or if something were to come in contact with that joystick, that could move it forward or in reverse besides the operator. Answer, yeah, if something pushes it, yes. That's what happened. He knows it can result in inadvertent movement. During this exchange, he's looking at some pictures that are being shown to him of men positioned behind the machine doing their work. Page 72 at the bottom. Question, if that joystick on the SPD6 inadvertently would fly all the way in reverse, it's foreseeable that it could run over these two workers, correct? Answer, It can cause an injury if, the operator doesn't rush and takes any safety measures. Here, not only was the operator, Mr. Benke, pinned into his seat by the cable that had fallen down, this happened by his own testimony, way too fast for him to hit the emergency stop button or anything like that. And while the defendants quote extensively from Mr. Benke's deposition, what they don't quote from is him saying he did everything right, there was nothing he could have done differently. And then most importantly, this is my last quote from Kumar, the current design engineer, he knows that the purpose of the safety lock is to prevent inadvertent movement. Question, so the SPD-6 does not possess the safety feature, correct? Answer, it does not possess the center lock, yes. Question, okay, and what is the purpose? What is any other purpose of having a center lock except for safety, operator safety? Answer, it is to stop the machine from going forward to reverse inadvertently, yes. That's it. The problem that the trial judge got into, Judge Cook got into, was he bought into this idea that we're not looking at the foreseeable risk, like the statute says. We're going to look at the foreseeable harm that actually occurred and whether that was foreseeable. And according to this logic, a manufacturer and a designer of a defective product gets a free pass if what happens is just so unforeseeable that nobody could have known that it would occur. And the OPLA doesn't say that. There's nothing in there that says that the harm that actually occurs is relevant in any manner. And where they're borrowing this from, although they don't say it so, it's from the common law, where in kind of the Paul's graph situation, we look at how the incident unfolded. But even then, under the common law, we don't focus on what actually happened. We're looking at what was foreseeable at the time. Was there foreseeability of some harm? So in Cromer versus Children's Hospital, medical malpractice case that came through this court, went up to the Supreme Court. The Supreme Court said in paragraph 24, the foreseeability of the risk of harm is not affected by the magnitude, severity, or exact probability of a particular harm, but instead by the question of whether some risk of harm would have been foreseeable to the reasonably prudent person. In both McKendrick and in Kumar, and our experts all say that, the risk of inadvertent actuation was well understood. And it's well understood that around this machine, both sides and back, they're going to have guys working, a whole crew. They knew this. And if there's inadvertent actuation, someone's going to get hurt or maybe even killed. They've admitted that. So getting into this wild, crazy circumstance that nobody could have foreseen is completely irrelevant here, and certainly at the summary judgment stage. There's just no free passes for freak accidents. The case the trial court misconstrued was Gay versus Mossberg, the 11th District in 2004. And there's 3 different opinions, so I'm not even sure there's really a majority opinion there. But it's a case about a teenager playing with a shotgun in his basement, and he shoots his friend. In the claims against the parents for negligence, the court finds, yes, it was foreseeable that leaving a loaded shotgun in your basement could result in harm. The plaintiff wins on foreseeability on that.
Counsel, I do want to alert you that you're going into your rebuttal time.
Okay, then I'll wrap up with this. But the expert in that case, the expert says, this guard I'm talking about, this warning device, the chamber-loaded warning device, it's not in any of my guns. I didn't think of it until after this accident, and this this gun is not necessarily defective. That was the problem in Mossberg. So with that, we would ask you to reverse. Thank you.
Thank you, Attorney Flowers. You will have 2 minutes and 35 seconds.
Good afternoon. My name is Jennifer Narone, and I represent Midland Machinery Company in this matter. The trial court correctly granted Midland's summary judgment pursuant to 2 independent grounds: the absence of foreseeability and the absence of probable cause. The trial court additionally indicated appellant did not meet her burden to prove a feasible alternative design existed that would have prevented this accident, but declined to formally rule on the issue given the absence of foreseeability and proximate cause. I will address each in turn, including some mistaken representations made by appellant. With regard to foreseeability, the trial court concluded this accident was not foreseeable to Midland due to the extremely slow pace with which the machine moves, the presence of safety features, and the absence of clarity regarding how stone ended up underneath the machine. Appellant contends through her briefs that the trial court misunderstood the foreseeability risk under the OPLA and in particular that Judge Cook believed a manufacturer must foresee a bizarre chain of events in order for an accident to be foreseeable.
Well, what does it matter how it happens if it's something, if the whole issue is, if you had a control device on a joystick, it wouldn't have moved. Now, you could go into proximate cause, you could go into all those different things, but what does that have to do with foreseeability, that it's a weird set of circumstances?
Well, to get to the point on the joystick, Your Honor, there actually is no evidence in the record that a center lock would have prevented this accident. Plaintiff's experts never went through the testing or analysis required to do that.
I thought there was testimony and deposition.
No, Your Honor, the reports have conceded, and the press deposition, which is not admissible in this matter because it was not part of the trial court record, nor was the coroner report that they constantly cite to. That is not part of the trial court record. But Kress conceded in his deposition he conducted no recreation of these events, did not test a joystick under these circumstances to determine how it would have interacted with these chain of events. Kumar, in his deposition, talks about the importance of testing a joystick center lock under these circumstances, which Ohio law generally requires you to do. First, let me talk about the McGrath case, because I think that's similar. In McGrath v. General Motors, the experts, which is nearly identical to the experts in plaintiff's case, it was a side impact system on a 1987 LeSabre. The experts for plaintiff pointed to a Taurus that had a side impact system and said, look, the Taurus has it, therefore the LeSabre could have had it. The court said, first, that's not enough. You need to take that impact system, you need to try to put it into the LeSabre to see if it would have even worked, if it was feasible to begin with. Plaintiff's experts never did that at all. They never took an SBD6. They never took a joystick, put it into the SBD6 that had a center lock, and said, look, this fits. They point to the SB8 and the SP10. They do have a center lock. However, what they didn't tell you is that the SB8 and SP10 center locks and their joysticks are not compatible on the SBD6.
And you have expert testimony that says that?
Yes, that is the testimony, and their experts conceded that as well.
But my understanding is one of the experts for the plaintiffs did testify that testing was not necessary, that he would opine that that joystick would have been moved.
Under Ohio law, that is not sufficient. The McGrath case gets to that. And Kumar gets to that. Lally was asked in his deposition, and that's Midland's engineer. He was asked in his deposition, if the road widener had been an SP8 or SP10, which had a center lock, would Mr. Stone have been run over, as happened here? Lally answers, I wouldn't be able to correctly answer that because I don't know how strongly the semi-track was pulling that cable. That lock on the joystick would be able to withhold that kind of force. That I don't know. Asked again, okay, that's what I want to talk about. What is the kind of force that the center lock? What kind of force would it tolerate? Lally said, I don't know, sir. When asked again if the center lock would have prevented the machine from moving, Lally responded, I do not know because I do not know how much power the semi was pushing or pulling the cable, and whether it was caught real heavy. And that I do not know these facts, sir. Lally is asked, who would have that information, sir? Lally said, I don't know how much information is available.
Was this the Midland's engineer?
This is Midland's engineer.
Okay.
So Midland's,
So they were not presented as an expert?
No, he's the engineer. And he is explaining, however, that in order to opine if the center lock would have prevented this accident, we need to know things like the weight of the cable, the speed with which it was moving, how much force it contacted the machine with. These are calculations that need to be done in order to opine that the center lock would have prevented this machine from moving. And McGrath gets to that. It says, plaintiff does not allege that her experts have done any computer modeling or research to determine how an Ultima with her proposed alternative design would have functioned under accident conditions identical to those of the case FR. Plaintiff's experts conducted zero testing, admitted to it. They admitted to not recreating this accident, to not trying to put a joystick into the SBD6. None of it. Under Ohio law, that is not sufficient of proof of a feasible alternative design. The cases are concrete on that fact. So I don't think we can say that it would have prevented the accident. There's no evidence that it would have, and the experts failed to prove that. On that independent ground alone, I think Midland is entitled to summary judgment. However, the court also talked about foreseeability and proximate cause. With foreseeability, the court believed the speed with which it moved, the safety features, and the fact that we don't know what happened to Mr. Stone that day make this accident unforeseeable to Midland. With regard to speed, the appellant has referenced in her brief that Midland has misrepresented the speed. Respectfully, that's not accurate. There are two modes to this machine, travel mode and work mode. At travel mode, it does move up to 8 miles per hour. Lally conceded that, there's nothing to hide. But there's work mode. In work mode, it moves at 150 feet per minute. That's 1.7 miles an hour. This machine was indisputably in work mode at the time. Benke describes this as, quote, very slow, quote, a slow walking pace. This is why Benke testified it was not possible that he could have gotten struck by this machine at the time. He agreed, not possible. It's an important word, possible. If it's not possible, how could it be foreseeable?
No, this was the operator of the. Correct.
This is Benke's, Mr. Christopher.
Okay, so he's not testifying as an expert.
No, he's testifying as the on-the-ground operator who has operated this machine for 8 years. So he does actually know how this machine moves and the risks involved with it. Second, the court believed that the safety features were important. There is a backup alarm that was operational that day. There is the parking brake, which works exactly like your foot brake in your car. It's down by the foot pedal. And then there's the emergency brake, a huge red button on the dash that takes just a second to hit. When you hit it, it deactivates the joystick and it stops the machine from moving by locking up the wheels. Lastly, there is an ignition key that you can turn. Even while the machine's moving and it would shut down the machine. With regard to the parking brake, Midland's manual instructs the operator, every time you return the machine to neutral, engage the parking brake.
Counsel, I guess I'm still, maybe not understanding, but it sounds like from your presentation and from the presentation in the briefs and both sides, that yes, there is testimony that says that, but at the same rate, like with the backup alarm, the parking brake and so forth, that is it Benke? Yes, that he had indicated that he would not have been able to effectuate any of those maneuvers in order to stop the machine.
No, Your Honor, that is not his testimony. When he returned the machine to neutral, the tractor trailer had not approached yet. Per the instructions on the manual, he should have put the parking brake on when he returned the joystick to neutral. The manual is very clear on that
Wasn't
issue.
there some evidence he wasn't trained on the manual?
He never read the manual. He admitted that he had not.
So he didn't really know what he was supposed to do.
He was not trained by Roniak and had never read the manual. He admitted to doing that. And the manual does say, quote, always apply the parking brakes when you return the drive stick to neutral. It also advises, which is a matter of common sense, when emergency is imminent, to hit the emergency button. We know Benke did have time, unfortunately. He raised his hands up to stop the tractor trailer. And if perhaps he had raised one hand or none and just hit the emergency brake, that machine would not have moved that day. Another important point the trial court noted was the fact that we really do not know how Mr. Stone ended up under the machine, unfortunately. He was standing to the left of the machine at the time of the incident, not behind it. Appellant keeps talking about this coroner report. There's two problems with it. It's not part of the record and cannot be considered on appeal. But second, it was issued on August 2020, which is before any fact witnesses had given any testimony in this matter.
Counsel, there's no need to even go into it.
Thank you.
Consider it on.
Thank you, Judge Sutton. So the facts taken together and the evidence as a whole, that we don't know how he ended up underneath the machine. How do we guard against the risk that we don't understand happened? And the speed of...
Counsel, just, on the basic question of the risk being the unprotected joystick and the inadvertent actuation of the joystick. Do you agree that that's the question about foreseeability?
I do not believe that the inadvertent risk alone is the question of foreseeability. I think it has to be taken not in a vacuum, but in the circumstances of this case. Even to inadvertently actuate this machine, it would be moving at 0.17 miles per hour. There's a backup alarm. Nobody stands behind it. The foreman testified that they are instructed not to be behind this machine. So for it to jump, it doesn't lurch quickly all of a sudden. So I don't think that the inadvertent actuation itself is the risk. I think the risk is getting struck by the machine and inadvertent actuation, and I don't think that risk is possible. I think it's low. The trial court.
But if there was no inadvertent actuation here, there would be no strike of the individual.
Not under these facts, Your Honor. It was in neutral, and the parking brake should have been on.
Okay, and I just want to have another question related to what opposing counsel stated regarding the standards, and the quote being, "The controls shall be protected."
The ANSI standards are not under compulsory of U.S. law, regulations, state Ohio law. They are not compulsory. Mr. McKendrick testified that when he had designed the machine, he looked at the standards and none were applicable.
So there
What
are
does that mean?
standards, I'm sorry.
What does that mean?
For-
Applicable, could you do
The case law is not clear on what applicable means, Your Honor.
okay, I'll let Mike.
No, I was just,
Call it
I
back.
think it's the same question.
Yeah.
You know, so the point is they're not obligated to go by these standards, but basically that's the rule that most engineers prudently here could follow.
Correct. And if you look at Mr. McKendrick's testimony on page 43, he actually does testify that we looked up standards. There were no standards when he designed it. So that's page 43. And I note that in Butts, the case of Butts v. OMG, that would just be one factor in the analysis, and it would not be determinative, that you would have to balance them. And I believe that when you balance them all together, that the answer is that this was not a foreseeable risk, and this product was not defective under Ohio law. There is an additional issue that I'd like to talk about with proximate cause, and those are the cases of Frias and Gominski. They specifically hold that the failure to follow the instructions in a manual is the proximate cause of an accident. They are never been discussed by appellant. He's never tried to distinguish them, let alone discuss them. They are good Ohio law, and they are on point here. Benke did not follow the instructions of this manual. If he had returned, when he returned the joystick to neutral, he should have engaged the parking brake. Had he done so, this machine never would have moved. Pursuant to Frias and Gominski, that is the proximate cause of this accident. We touched upon feasible alternative design before, so I will not repeat those arguments. If your honors don't have any more questions, Midland would rest.
Hearing none, I thank you for your presentation.
Thank you, Your Honor.
Thank you, Your Honor. 2 minutes and 40 seconds. I'll cover a few points. Just to follow up on Judge Carr's question, I'm not aware of any expert testimony from the defendants in the record. They have the burden of establishing proximate cause for summary judgment purpose. Unless I missed it, and I don't think I did, there's no affidavit from an expert on the defense side establishing that no proximate cause exists. And that's because the argument is absurd. About force and so forth, we know from the post-accident investigation, and we know from the photographs, there was no damage to that joystick controller. We know that this cable came across and wrapped around the operator, Mr. Benke, and didn't hurt him. There was no force anywhere near what would have been necessary to break off the travel lock. And if this thing is so flimsy, why do they use it on their larger models, the SPD8, the SPD10? Why does everybody else use it? Why is this the only road widener that we know of in the world that doesn't have this safety feature, which would have stopped this from ever happening? I mean, if that center lock is on there, and with the force of that cable coming down being as slight as it was, Mr. Stone would be alive. I'd be back in my office working another brief. We wouldn't know anything about this. But for the absence of the center lock that the ANSI standards required, this accident never would have happened. That's proximate cause. And I agree, proximate cause is not a dispute, but it's not a dispute for them. As for our experts, remember, Judge Cook is the one who decides whether or not expert testimony is admissible. He never says, despite all their nitpicking, He never says that the Kiefer Crest reports are inadmissible. He just ignores them. So there's no reason for this court to ignore them. That wasn't a cross appeal. And remember, Hartman versus Erie Insurance case, which we've cited, says that experts don't need testing. And you don't need it here because you can look at the investigation and see that you didn't have anywhere near the force that would have caused the center lock to fail. It just wasn't there. That's why we don't need testing. We've got reliable, objective information supporting our expert testimony on proximate cause, which both McKendrick and Kumar give us anyway. They say the purpose of the center lock is to prevent inadvertent movement. And if you don't want to do the center lock, our experts say you put a cover over it, that only the operator's hand can go in, and that'll serve the same purpose. Just as far as going to the speed, remember, Benke's got every reason in the world to try to exonerate himself. Nobody wants to be responsible for a death. And certainly Kumar, who they're quoting extensively, he designed this thing. He's not going to admit that he did anything wrong. He's going to try his best otherwise. But I still read you the admissions he had to make. He knew that there was a risk here. He knew they didn't do anything. He knew that they had the center lock available there. And I'll just leave you with the last quote from him. He's given an opportunity to explain why they didn't put it on here. Oops.
Council, I'm gonna have to ask you to wrap up.
Yeah, it was too long for me to get it anyway.
While you're doing that, is the coroner's report part of the record?
Through the Keefe report, he quotes it. Chris? I bet it's in Keefe too.
And Keith did.
Yeah, but I have it down as page 6 in Keefe's supplemental report. He quotes the coroner's report, which conclusively establishes what happened here. Thank you.
Thank you both for your presentations. We will take them under advisement and issue a decision in due course. The clerk of course will mail a copy of that decision to you on the day that it is released, and the opinion will also be posted on the Ohio Supreme Court website. Thank you again.